Hello, everyone, and thank you again for joining us for another Copyright Essentials series webinar. Today, it's for musicians. Find your voice. My name is Alicia Morris, and I work in the Public Information Education Office, and I'm the host of today's webinar. Before we start, I'd like to share just a few logistic announcements with you. During today's webinar, you will be able to submit questions using the Q&A button at the bottom of your screen. We'll answer these questions after the presentation is complete. However, we may not be able to answer all of them. And since this session is being recorded, please note that if you choose to participate and your question is addressed, it will be included in the recording as part of this webinar. And now I would like to welcome our today's moderator, George Durrani, Deputy Director of the Public Information and Education Office. Hello, George.
Thank you, Alicia, and hello, everyone. I'm so happy to welcome you to today's webinar, Find Your Voice, Copyright Essentials for Musicians. This is the second event in our three-part educational series from the U.S. Copyright Office, where we break down copyright law by creative field. Today, we're focusing on musicians, whether you're a performer, songwriter, or both, or just interested in the topic. We'll talk about the difference between musical works and sound recordings, walk through ways to register your works, and share how our Public Information Office can support you. Leading today's session are attorney advisors Jessica Chinnadurai and Laura Kaiser. At the Copyright Office, one of our main goals is copyright for all. That means we're working to make the copyright system as clear and accessible as possible for everyone. This webinar series is an important part of that effort, and we're thrilled to see so many of you here with us today. In fact, we had hundreds of people register from all across the US and nearly 60 countries as well. And we know that many people enjoy these webinars at a later date. Thanks again for joining us. And now I'll hand things over to Jessica to get us started.
Thank you so much, George, and hello, everyone. Thank you for joining us today. Again, we are so thrilled that so many people want to learn about copyright. And today's session is the second in a three-part series that we're hosting this year, where we will explain copyright as relevant to three professions: visual art and photography, musicians, and writers. Before we get into today's session, just a few logistics. This event is being recorded and captions are enabled. And throughout today's webinar, we will highlight a few resources, and associated links will be dropped into the chat throughout the program. There will also be a survey after the webinar that we would really appreciate you completing, because we do develop programs like this with your feedback in mind. So as George mentioned, today your presenters are myself, Jessica Chinnadurai, and my colleague, Laura Kaiser. We are both attorney advisors in the Public Information and Education Division of the Copyright Office. We frequently participate in outreach projects like this webinar, and we enjoy breaking down copyright and helping the broader public understand what it is. For a brief overview of today's presentation, we first have planned an overview of the Copyright Office, including some history. Then we'll talk about the basics of copyright law before getting into some common questions that we hear from musicians. We'll provide some considerations and important points to remember, and then we'll cover copyright registration, a few application options geared towards songwriters, performers, and others in the musical professions. In case you're not a musician, as George said, just listening in for fun, the first webinar in this series covered copyright essentials for visual artists and photographers, and a recording of that webinar is now available on our website. And then later this year, look forward to the third event in this series for writers, where you can expect the same sort of setup, except geared towards your specific profession. Today, you will also hear from staff in our Public Information Office, which fields thousands of inquiries every year over the phone, email, and in person. And we thought it was important for you to meet them and know that you can contact them anytime. And then lastly, we'll end by answering a few questions from the audience. So if you missed the announcement in the beginning, please just use the Q&A function to submit those. With that, I'll pass the floor over to Laura for some history.
Thank you, Jessica, and hello, everybody. So the United States Copyright Office was founded in 1870, and we are a government agency that is part of the Library of Congress in Washington, D.C. So we are part of the legislative branch of government. And when we talk about the Copyright Office administering the Copyright Act, that's a pretty broad statement and has a number of different roles associated with it. So let's look at the various ways that the Copyright Office carries out its mission. The office has several important duties that help fulfill copyright's constitutional purpose. Our mission statement is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial, expert advice on copyright policy for the benefit of all. Our small but mighty staff of about 470 employees have many different responsibilities. First, we make and maintain records that provide details on copyright ownership. So that includes registration records, as well as recorded documents about transfers of ownership. We also administer statutory licenses and help distribute royalties as required by law. And Congress has delegated authority to the office to develop regulations concerning many areas of copyright. The subjects of those regulations include a wide range of topics, including rules governing submissions to the office, such as different types of copyright applications, fees that are paid for the office's services, filings that are related to statutory licenses, FOIA requests, and more. These regulations provide the public with a well-functioning copyright system. Now, copyright law is found in Title 17 of the U.S. Code, also known as the Copyright Act. And the law states that copyright protects original works of authorship that are fixed in a tangible medium of expression. So what this means is that we first must have a work of authorship, and that work must be fixed and original in order to be protected by copyright. Now, Jessica will go over some of the work of authorship categories, and particularly the ones concerning musicians, in more detail in a moment, but let me just take a few minutes here to explain what fixed and original mean. Fixed basically means that the expression must be written, recorded, or otherwise captured in a copy, and it needs to be sufficiently permanent or stable enough so that it can be perceived, copied, or communicated for more than a transitory duration. The important thing here to remember is that the moment a work is fixed is the moment that copyright protection actually begins. And originality in copyright involves two components. The first is independent creation, and the second is sufficient creativity. Independent creation means that the work needs to be independently created by the author. So the work needs to originate from the author and it cannot be copied from another work. In theory, you could have two works that are the same or similar, and they could each have copyright protection as long as those similarities are simply by chance and not the result of copying. Now, sufficient creativity requires that the work contain at least a small amount of creative expression, but that small amount must be more than trivial. For example, short musical phrases do not have enough creative expression to be protected by copyright. Over to you, Jessica, for more details on works of authorship.
Great. So the phrase works of authorship means the subject matter protected by copyright. The broad categories include the list that you see here. So literary works, for example, books, magazines, poetry, and computer programs. Musical works, including any accompanying lyrics. Dramatic works such as plays and operas. Pantomimes and choreography. Pictorial, graphic, and sculptural works, including fine and graphic art. Examples here include paintings, drawings, maps, wallpaper designs, and more. Motion pictures and other audiovisual works, for example, movies, television shows, advertising videos, and video games. Sound recordings, including audiobooks and podcasts. And finally, architectural works, which might include houses, office buildings, and museums. So our focus today is musicians, and the works of authorship that might apply include first, dramatic works. For the purposes of copyright registration, a dramatic work is a composition, generally in prose or verse, that portrays a story and is intended to be performed for an audience. So examples include stage plays and musical plays, and then there are operas as well. Additionally, another relevant work includes a musical work, which is the musical composition and lyrics of a song. And then lastly, we're also talking about for musicians sound recordings, which is the recorded performance of sounds other than those in a motion picture or a movie. So examples of sound recordings could include audiobooks, that's the recorded performance of someone reading the book, a podcast, or of course the recorded performance of music. And today we will be focusing mostly on musical works and sound recordings. So just wanted to break down the difference between the two. When you record a song, you may be creating two different works that can be protected by copyright law. First, a musical work, and then second, a sound recording. So these works are subject to different rules under the Copyright Act and are commonly owned and licensed separately, which is what we'll cover in the next few slides. Starting here with the basics though, a musical work is a song's underlying composition along with any accompanying lyrics. And elements of musical works that it could appear in a composition include the melody, rhythm, and harmony. And a musical work might include lyrics, which are a set of words, sometimes grouped in verses or choruses that are intended to be accompanied by music. On the other hand, a sound recording is a series of musical, spoken, or other sounds fixed in a recording medium, like a CD or a digital file, and that's what we call a phonorecord. Note, of course, that sound recordings are not limited to recordings of musical works. They can also be recordings of lectures or podcasts or other audio recordings. But let's take a closer look at who the author and owner of a musical work is. For those who aren't familiar, the word author refers to the work's creator. And the author of a musical work is typically going to be the composer, the lyricist, or the songwriter. As the initial author, this person is also the copyright owner. And in the case of a band who co-writes the composition and lyrics, those joint authors are joint copyright owners as well. The copyright owner of a musical work has the rights to make and distribute copies of it, publicly perform or display it, and make derivative works from it. So think about interpolations, remixes, or even videos using the musical work. All in all, those are what we refer to as the exclusive rights. So anyone else who wants to do these things must either secure a license from the copyright owner, use a statutory license, or have an exemption apply, like fair use. And a statutory license is created by operation of law, not by a contract. And with a statutory license, a copyright owner cannot say no to uses of their works as long as the licensee complies with applicable legal requirements. Doing the same deep dive into sound recordings, the author of a sound recording can be the performer who is being recorded, the record producer who processes and fixes the sounds, both of those individuals, or the sound engineer, or even another entity if the work qualifies as a work made for hire. So the author of a sound recording is the initial copyright owner as well, but a work made for hire is an exception to this general rule. With works made for hire, the employer or the commissioning party of an eligible work is considered the copyright owner. A copyright owner of a sound recording has the rights to make and distribute copies of the sound recording, which again are called phonorecords. And phonorecords are basically the material objects in which sounds are fixed. So the copyright owner of a sound recording can also make derivative works from it, including remixes or videos that incorporate that sound recording. However, the public performance right for sound recordings is limited to digital audio transmissions. And an example of a digital audio transmission is streaming the sound recording online. Lastly here, unlike musical works, owners of sound recordings do not have a public display right. So with that kind of high-level overview of the difference between musical works and sound recordings in mind, let's dive into some of the questions you might have asked yourself about copyright as a musician. Before we begin, just a really brief and important note, the office does acknowledge, and we completely understand, there are many questions and topics to address when it comes to copyright music, too many probably for a 1-hour webinar. But what we've done is tried to simply compile the most frequently asked questions with the objective to help explain some considerations to keep in mind and then points to remember or takeaways when it comes to music and copyright. So I'll get us started with this first question here. What if my band creates a song as a group? Who owns the copyright in the works that we create together? The copyright concept that's important to consider here is what we call a joint work. So a joint work is a work prepared by two or more creators, and those creators must intend to merge their contributions into one single work. That means that when the creators made their contributions, they planned to combine them into an integrated work. So you might be able to tell intent is a focal point. It's very important when considering joint works. And as a result, the creator's plan should be in the form of an agreement or other clear indication that the creators were clear about their intentions. Looking closer at each creator's contributions, first, the office's position is that each author of a joint work must contribute a sufficient amount of original authorship, which just means that copyright could protect the individual contribution on its own. So if one person maybe suggests the idea for the band's next song, but one person actually writes the composition and another person writes the lyrics, the person who suggested the idea is not a joint author. Second, the individual contributions must be merged into inseparable or interdependent parts of the whole work, in this case, the whole song. And inseparable here just means that the contributions cannot be separated out. It's basically not clear who created what. This often applies to works that contain a single form of authorship. Think about like a novel without any illustrations. If it's just all text that was jointly written, it's unlikely that as you're reading it, you could identify, which sentence or which paragraph was written by each author when you're reading the whole work. And song lyrics as a standalone work could be another example here. As for interdependent, that means that when the joint authors' contributions are interdependent, they depend on each other to create the full, complete, and wholly original work. And this often applies to works that contain multiple forms of authorship. So think about a motion picture where you have elements of direction, cinematography, you also have a score, or think about a song where you have music by one person, lyrics by another. You can separate out those contributions so they are separable, but without one, you wouldn't have the complete song, which includes the lyrics. So those contributions are then interdependent. Some takeaways to remember here are that an initial author or creator of a work is also the copyright owner, and with joint works, all authors are co-owners of the copyrights. Each owner has the right to exercise any of the applicable exclusive rights in the Copyright Act, and the exclusive rights in copyright include, again, the right to make copies, distribute copies to the public, make derivative works, and then for certain works, publicly perform and display them. So there are 6 total. With joint works, any copyright owner can transfer one of the exclusive rights or all of them, or they can authorize others to use the work in one of the ways provided by the exclusive rights. So for example, one owner can authorize someone to publicly perform the jointly created musical work, and they can do so without permission from the other co-owners. Now, the thing is, if one copyright owner does that, they must share royalties or profits with all of the other copyright owners unless there is an agreement that says otherwise. A follow-up question that we often hear related to this concept is, what happens if the band later breaks up, or, does the copyright end when the band breaks up? If the band breaks up, that doesn't automatically change copyright. Unless there's a contract or other written agreement that states otherwise and provides the terms of what happens if the band were to split up, the co-creators are still the co-owners in the copyright. And copyright doesn't end when the band splits up. Instead, it lasts for 70 years after the death of the last surviving author. So in general, copyright lasts from the moment the work is created and for the life of the creator, plus an additional 70 years after their death. But in the case of a joint work, there's more than one creator, so copyright lasts for 70 years after the death of the last surviving creator. Now, we've covered a lot of ground with this first question. If you're interested in learning more in your spare time, the office does have a Learning Engine video series available on our website as well as YouTube. And one of the videos is called Copyright in Collaboration, and it discusses joint works in detail. So we will link to that in the chat now. And I'm going to pass the mic over to Laura to take us through a few additional questions.
Thanks, Jessica. So for our next common question, can I cover a song without obtaining permission from the copyright owner? So let's start with what a cover song is. A cover is made when a previously recorded musical work is re-recorded into a new sound recording. So the distinction between musical works and sound recordings is important here. When you create a cover, you're utilizing someone else's musical work, the underlying composition with any lyrics, and possibly making your own sound recording. Now, you might try and imitate the earlier recording, but you might also include your own interpretation and style. The key to remember here is that when you're planning to create a cover, by definition, there's another work, the musical work that you're using, and you should keep in mind whether you're using it in a way that conflicts with the musical owner's rights and whether your use is lawful. Jessica just mentioned that copyright owners of musical works have 5 different rights: the right to copy, make adaptations of their work, distribute their work, publicly display or publicly perform their work. Generally, you have the following options if you're going to make a cover. You can use a musical work that's in the public domain, so meaning no one owns the copyright in it. You can ask for permission from the copyright holder, license the work according to a licensing contract, or rely on a statutory license or exception. So let's say you're a performer and you'd like to perform or record a cover. How would you obtain permission from the copyright owner of the underlying musical work? Well, the Copyright Office's records are a great place to start. Our Copyright Public Record System, or CPRS, will soon become the sole source of authoritative online copyright information. It has advanced search capabilities and allows you to download, email, and share registration records. Crucially, the records on CPRS might include what we call rights and permissions information. So that would allow you to reach out to a listed contact if you're seeking permission to use a work. Remember also that if you try but are still not able to contact the rights holder for the musical work, you still don't have permission. Copyright owners often have representatives in charge of licensing their works and certain types of uses of their works. So for example, you might need to contact the music publisher or the performing rights organization that would then manage the licensing contract with you for the cover. Keep in mind that in most cases, the public performance right for musical works is licensed by a performing rights organization, such as ASCAP or BMI. And that brings us to another option, statutory licenses, which we've mentioned a couple of times already. These are also called mechanical or compulsory licenses. So let's say you're a musician who covers a song and you'd like to distribute it. As Jessica mentioned earlier, statutory licenses are created by law, not contracts. And with statutory licenses, you don't need to ask for permission from the copyright owner to record a version of their musical work, as long as you're complying with all the legal requirements for the license as they're written in the Copyright Act. Now, some of those requirements can be a bit complicated. For example, new musical arrangements are allowed, but the arrangement cannot change the basic melody or fundamental character of the work. Additionally, the purpose of creating an audio-only recording of the musical work must be to distribute to the public for private use. Under the statutory license, a user cannot distribute a phonorecord for any public use, and that includes for use in background music systems or broadcasting, for example. But what if you're on the other side of this and you're the copyright owner of the musical work that was re-recorded as a cover and it's now being offered on interactive streaming or for digital download? So while the traditional system for obtaining statutory licenses for those non-digital formats like CDs or vinyl remains in place, the 2018 Music Modernization Act, or MMA, updated the way that copyright owners of musical works are paid when their work is played via those interactive streaming services. So specifically, the MMA changed the process for obtaining a statutory license for digital transmissions of a sound recording to someone who can download it on a permanent or limited basis or who's interactively streaming that sound recording. For more information on the MMA as it relates to statutory licenses, the office has a really great handout called Sampling, Interpolations, Beat Stores, and More, and we'll drop the link to that in the chat. So for our next question, how do I know if my musical work is considered published? So for example, what if I perform it at a park? What does that mean for publication? This question is important because when you apply to register a work with our office, you're the one who must determine whether your work is published on the application itself. Publication will also affect how long copyright lasts for your work and the accuracy of any copyright notice should you choose to use copyright notice on copies of your work. Adding copyright notice isn't required to have copyright protection, but it does have some benefits. And for those who don't know, copyright notice has 3 parts to it. It's the C in a circle or the P in a circle for phonorecords, the year of first publication, and the name of the copyright owner. Additionally, for non-US residents or citizens, publication is crucial to understanding whether and to what extent a work is protected under US law. So just to reiterate the question, how do I know if my musical work is considered published? Let's start with the definition. So publication occurs when copies of a musical work are distributed to the public, and distribution might occur by transfer of ownership, sale, rental, lease, or lending. And publication can only occur if it's authorized by the copyright owner. So only the owner of the musical work can publish a work or authorize others to do so. Remember that where and to who the work is being distributed does matter here because the law specifies that distribution must be to the public. The public has a particular meaning in copyright. It's a place open to the public or a place where a substantial number of people who are not known to each other are gathered. So not just a group of family and friends or social acquaintances. So for example, handing out copies of sheet music at a local park, that'd be a distribution to the public. But sending a copy of your sheet music to a friend, telling them not to forward it on, that would not be a distribution to the public. And what about that next part of our question? What if you perform a musical work publicly? Our question gave the example of singing your song in a park. What about singing it on a busy street corner? That would be a public performance, but in the law, it specifically states that a public performance by itself does not make a musical work published. So just to contrast this, a non-public or a private performance might be something like playing a musical work at a birthday party that's taking place inside someone's home. Another frequent question is whether the musical works performed or posted online are considered published. For example, what if you perform your song on YouTube Live? Does that mean that you've published your musical work? So while performing your song on YouTube Live is likely a public performance, remember that publication is a distribution of copies to the public or an offer to distribute. The Copyright Office's current position is that a work is published online if the copyright owner authorizes the end user to retain copies. So for example, if the owner authorizes copies or downloading by members of the public, or if the owner themselves makes those copies available online and offers to distribute them to a group for further distribution, for further public performances or public displays. And remember here too that publication was a part of copyright law before the internet, so online publication in the context of copyright continues to be a complicated topic and one that the office continues to look at through an open rulemaking. But in the meantime, we hope that this provides you all with a helpful foundation if you run into any questions about publication as a musician. Over to Jessica for our final industry question.
Thanks, Laura. So for our educators listening in, whether that be in music or another topic, we do often receive questions about making copies for classes. And in this example, the question is, I teach music in my spare time, so can I make copies of sheet music for my students? Let's first start with the consideration that the exclusive rights we've discussed throughout today's presentation are limited. This means that in the Copyright Act, there are several limitations and exceptions provided which allow for certain uses and oftentimes by very specific users without the copyright owner's permission. Relevant to this question is that some limitations allow for educational uses. So one example is that Section 110 of the Copyright Act allows for someone to perform or display a creative work in face-to-face teaching activities at nonprofit educational institutions. It's important to kind of look into that further and consider that face-to-face teaching activities, for example, does not include or encompass online classes. And then the location where this exception applies or might apply is a nonprofit educational institution, very specific. Importantly, too, this exception applies to performances or displays, not the reproduction right, which involves making copies and is the call of the question here. So for example, if all of these criteria are met, an instructor or a student might be able to display a workbook on a large screen in a classroom, or they might be able to play a musical work from the Hamilton soundtrack during an American history class. But in general, all relevant criteria spelled out in the Copyright Act must be met for a limitation to apply and for an eligible user to use a work without the copyright owner's permission. Fair use is just a little different. Fair use is a legal doctrine that permits the unlicensed use of copyright protected works in certain circumstances. And we mention it here because in Section 107 of the Copyright Act, where you have the framework for understanding whether something is fair use, it does identify that certain types of uses, including teaching, scholarship, and research, it identifies it as examples of activities that may qualify as fair use. So the Office's Fair Use Index, which we'll link to in the chat now, has more information about each of the 4 factors weighed in a fair use analysis and how courts evaluate each. But that's really the main takeaway we want you to remember. The courts evaluate fair use on a case-by-case basis. Not all educational uses are fair, but courts are more likely to find in favor of these uses. However, just remember that the outcome of any given use depends on a fact-specific inquiry. So there is no formula to ensuring that a predetermined percentage or amount of a work, say a specific number of words or notes or lines, can be used without permission. And finally, just remember too that if fair use or another limitation does not apply, then the answer to the question of can I make copies of sheet music for my students is that you must ask the copyright owner for their permission to make copies of their musical work or secure a license. And remember, if you use the sheet music to publicly perform the work, that involves a different exclusive right. Now, if you're interested in learning more about copyright and educational uses, we do have another Learning Engine video that we'll link to in the chat at this time. So that was our last industry question for the day, but remember that we will do a Q&A. So if you have any follow-up questions, you're welcome to put those into the Q&A feature. But the next topic that we want to cover is copyright registration. So although your work is protected by copyright from the moment it's fixed, you can register your work with the U.S. Copyright Office, which is the sole administrator of the registration system in the United States, for some additional benefits. One benefit is that registration creates a public record that includes key facts about the work that's being registered, such as the name of the author, the owner of the work's title, if it was published, what date it was published, and the nation of first publication, etc. Along those same lines, the registration record may also provide the name and contact information for the person or organization who can receive requests for those seeking permission to use the work. And although registration is generally voluntary, it is required if you find yourself in a copyright dispute and would like to access federal court or the Copyright Claims Board, the CCB. So copyright infringement occurs when any one of your exclusive rights in the work has been violated. So the work has been copied, publicly displayed or performed, distributed, or made into a derivative work without your permission. And if your work is infringed, it must be registered with the U.S. Copyright Office, or the office must have refused registration in order for you to file a copyright infringement lawsuit in federal court. Federal court is just one avenue to resolving copyright disputes, and the Copyright Claims Board, or the CCB, is a 3-member tribunal within the Copyright Office that is an available alternative. If you file a claim with the Copyright Claims Board, you must either have a registration from the Copyright Office for the work at issue, or you must have submitted an application to register the work either before or at the same time as when you're filing your claim. So registration in terms of the process itself is relatively straightforward, and there are 3 basic requirements to keep in mind: a completed application, the filing fee, and a deposit, which is just the phrase that refers to a copy of each work that you want to register. So for example, a copy of your musical work or a copy of your sound recording. An application form is how you submit those details that we talked about being on the public record. So who the author and owner is, the title, maybe the year it was created as well. And we'll cover fees on the next slide, but want to focus on the deposit copy just a little bit more here, which is how the office examines the work that you want to register. So for musical works, what type of deposit you submit depends on the format in which the musical composition is produced and whether and where it is published. So as Laura mentioned just a minute ago, publication is a very important determination to make during the registration process. And common formats for musical work deposits include physical or digital sheet music with those accompanying lyrics. As for sound recordings, the office strongly encourages you to submit the deposit as a digital file when you're registering a sound recording that is either unpublished or published, solely in a digital form. So when you are registering a sound recording published in a physical format, such as a CD or an LP, you should submit the work in the physical format, even if there is a corresponding digital version. With registration benefits and requirements in mind, I'll explain more about timing and costs next. So on average, registration applications submitted online are processed in about 6 weeks when no communication between our registration program and the applicant was needed. That's what no correspondence means on the slide here. When the office does need to communicate with you, the applicant, the average time to process increases slightly to just over 3 months. And lastly, in terms of cost, that depends on the number and type of works you want to register. So the general rule is that you must submit one work with one application, and our least expensive form here is $45. In most cases, a musical composition and a sound recording must be registered separately. However, in limited circumstances, the sound recording and its underlying musical composition can be registered with one application, and Laura will cover this in just a minute. But on fees, the office has also created a number of group registration options that allow you to submit more than one work on one application, which just helps make the process more efficient and cost-effective. Most of the group options are required to be submitted online, and those applications range in cost from about $55 to $95. So you can learn more about fees at the link on the side, and then we'll also add a link to our registration homepage in the chat for your future reference as you navigate the registration process or as you have questions about benefits, requirements, processing times, or costs.
Great, thank you. So Jessica just went over the general registration requirements, and we also wanted to go over the different registration application options for musicians specifically. The standard application, the group registration of unpublished works, and group registration of works on an album of music. So let's start with the standard application here. Because musical compositions, musical works, and sound recordings are two distinct types of works, as Jessica just mentioned, generally speaking, separate registration applications should be submitted for each. However, if certain requirements are met, both the sound recording and the underlying musical composition can be registered on one standard application. First, both the musical work and the sound recording have to be on the same copy or recording file. And second, the copyright owner must own both the musical work and the sound recording. So for example, if a singer-songwriter performs and records their own composition, that singer-songwriter could use the standard application to register both the composition and the recording. Now, the standard application only allows registration for one song, right? So one musical work and one sound recording that meets those requirements. And we do have a great circular that goes into detail on this topic. That's Circular 56A, Copyright Registration of Musical Compositions and Sound Recordings. And we encourage you to check that out. We'll put the link in the chat. Circulars are great plain language guides to many different areas of copyright, including registration issues. Okay, but what if you have multiple musical works and sound recordings to register? Well, then you would be looking at our group options. We're going to focus on the group registration of works on an album of music, or the GRAM, today, but there is another option for musicians called the GRU, or the Group Registration of Unpublished Works. That's GRUW. And for more detail on what's required for that option, we'll put the main page for that in the chat so you can look into it more. But let's spend the rest of our time for group options looking at the GRAM today. The office also has a dedicated web page for the GRAM, and we do recommend you check out that page for more resources, but I'll go through some of the basic requirements for you here today. So first, for the GRAM, all of the works must be published on the same album. And in the context of the gram, an album is at least 2 musical works or sound recordings on a phonorecord. Second, unlike the standard application, musical works and sound recordings cannot be registered together on the gram. So you'll need to choose whether you are registering a group of musical works with or without the accompanying lyrics or sound recordings. With the sound recording option, you can include any associated liner notes, photographs, or artwork that are distributed with the album. Third, all works on the gram must have been created by the same author or share a joint author. And the copyright claimant or co-claimants for each work in the group must be the same persons or organization. Now, we don't have time to go over every detail for this group option today, but just another quick note that previously published individual tracks or singles can also be included on the application as long as the single and the track on the album are the same. You do need to provide the first publication date of the single, and the single needs to be first published in the same nation as the album. So that's emphasizing the importance of publication again there. All right, so we just spent quite a bit of time going through registration basics, group registration options for musicians, including some of those nitty-gritty details. We understand it is a lot of information to digest, and you might be asking yourself, well, what if I don't know where to get started, or I can't really find the answers to my copyright questions? Well, look no further. Located within the Public and Information and Education Office is our office that can provide a practical pathway to success, and they do it all with a smile. Today, we are joined by a colleague from Public Information Office, Tanya Lewis, who can tell you more about the work that she and her colleagues do every day. In just a moment, Tanya will explain some of the services that the office offers. But just before we begin, just keep in mind that staff cannot provide legal advice. Some areas that might include legal advice include assessing whether your use is fair use, drafting or interpreting any contract terms, evaluating that publication status, weighing your registration options, or providing any opinions on alleged copyright infringement. But we do want to make sure that you're all aware of what the office does provide. So Tanya, thank you so much for joining us. Please tell us a little bit about yourself.
Thank you, Laura. Good afternoon. I'm Tanya Lewis, one of the senior information specialists in the Copyright Public Information Office. I've been in and around the Copyright Office for 30 plus years.
Awesome. Thank you so much, Tanya. So let's dive into it a little bit more. Can you tell us more about the Public Information Office and what you do every day?
The Public Information Office, or PIO for short, is part of the Office of Public Information and Education and is central to the Copyright Office mission and outreach goals. PIO is a team of 20 subject matter experts responsible for responding to thousands of inquiries each year from members of the public in the United States and around the world. As a senior copyright specialist here in PIO, I greet and assist members of the public with questions about copyright law, the registration process, the benefits of registration, and I also provide walkthrough assistance. My colleagues and I provide these services by telephone, email, in person when people visit us here in Washington, D.C. My favorite part of working at the Copyright Office is helping musicians create accurate records about their work. I have a love for the record and the importance of it.
Great. So let's take a little bit of a closer look at some of those services that PIO provides, starting with the walkthrough that you mentioned. For those who might be unfamiliar, can you describe that service a little bit more?
Yes, PIO can provide walkthrough services between business hours over the phone to help you complete your online registration application during a 30-minute appointment. Our business hours are between 8:30 a.m. and 5 p.m. Eastern Time, so the last appointment can be scheduled for 4:30 p.m. During a walkthrough, a staff member will assist you with navigating an electronic registration application by explaining the application screens and the types of information required. The office can provide you with information to help you reach decisions about how to answer application questions, but we cannot provide you with any legal advice. To request a phone walkthrough, you must request an appointment at the link being provided in the chat. When requesting a walkthrough, it is imperative to follow the directions and the steps to confirm your scheduled appointment. Once you have submitted your request for walkthrough assistance, your form will be considered tentative until a staff member corresponds with you to confirm your appointment. If you do not reply to the confirmation email by 5 p.m. Eastern Time the day before, you will not receive a walkthrough assistance. You will then need to complete another appointment request using the online form.
Thank you, Tanya. As you can tell, it's really important to follow all the rules that we have so you can make the most of your time with PIO and get the most out of that appointment. So thank you, Tanya. You discussed all about walkthroughs and how they're provided on the phone. What if somebody would like to come on site to Washington, D.C. to obtain assistance?
The office welcomes visitors to PIO in the Library of Congress, James Madison Memorial Building in Washington, D.C. Again, we're open Monday through Friday, 8:30 a.m. to 5 o'clock p.m. Eastern Time. We are closed on weekends and federal holidays. We can re- you can request an appointment at the link being provided in the chat now, or you may also walk in during normal business hours. Please note, as with the phone walkthroughs, the last on-site walkthrough we can provide is at 4:30 p.m. There are several services we provide in person. For example, walkthroughs can be requested on site using our kiosks. If you do not schedule an on site visit for a walkthrough ahead of time, however, please note that this service will be provided on a first come, first served basis between scheduled appointments. That's also the general rule for all walk ins. When visiting the office, you can also request certified copies of registration certificates and deposit, which is another name that for the copy of the work that you must submit with registration application. And lastly, members of the public can submit requests for search of the office records. This is a service often used by people who are interested in investigating whether a work is under copyright protection, and if so, the facts of the copyright. For example, the copyright owner's name. For a fee, the office will search its public records and provide a report of its finding. We'll give you a rough estimate of how long it would take to process these kinds of requests. There's also a lot of information you can find online at the link we're adding to the chat.
Thank you so much, Tanya. You described some of the really critical work that PIO does, and I know that you and your colleagues love answering questions from the public. I know our audience is very grateful for the services that you all provide. What else would you like them to know about PIO?
All PIO staff speak English, and we also have several specialists on the team who are able to assist you in Spanish over the phone or email. You may request assistance in Spanish speak from a Spanish speaking specialist by sending a request to the email address on the screen or by submitting a request using the form at the link being provided in the chat. Additionally, the office has informational resources available in Spanish, including circulars, handouts, and FAQs. Lastly, remember that the Public Information Office is ready and eager to help you. So please get in touch with us today if you have any questions about copyright or want to learn more about the services we provide. Thank you for joining today's webinar, and we look forward to hearing from you. With that, I'll pass the mic back to Jessica and Laura.
Thank you so much, Tanya, for being here. I know our audience really appreciated that, as Laura mentioned. And at this time, we are happy to take a few questions from the audience today. So George Tironi will be returning to help with Q&A. George, do we have any questions from the audience?
Wow, we sure do. So much information and a really engaged audience with lots of questions. So I'll remind everybody that Tanya and her colleagues are standing by to answer individual questions by either phone or email because we won't be able to get to all of your questions today, but we'll get to a few of them. Here's the first one. This is for Jessica. Is my band name protected by copyright?
Oh, that's a great question because we talked about bands. And so, in terms of the band name, no, copyright does not protect a band name because copyright does not protect words, short phrases, and that does include things like names. For our audience listening in, you may want to consider whether your band name is something that you could receive trademark protection for. That is something that is available through a federal agency, the U.S. Patent and Trademark Office specifically. And that's because trademark law is different than copyright law. And that's another important takeaway for our audience.
Okay, great. Thank you. Here's another good question. If I'm a member of a band and we create a song, is that considered a work made for hire? Laura, would you like to take that one?
Yes, thanks, George. So, yeah, work made for hire is another topic in copyright law, and it's good to know what it means. So, there are two options for when you know if you have a work made for hire. The first is that it's a work that's created by an employee in the scope of their employment. So, there needs to be an employer-employee relationship there. Or it can be what is in the law called a specially commissioned or specially ordered work. And that's when it's for a particular use, there's an express written agreement, and it's signed by all the parties. For the specially commissioned category, there's a list of works that can qualify for that. And sound recordings and musical works are not on that list. So generally speaking, you would probably need for them to qualify under that first option, the employer-employee relationship. But it's possible that musical works could be under that specially commissioned category if they're a contribution to a collective work. So that's a topic we didn't delve into depth in today, but as I mentioned before, our circulars are great plain language guides and have all the definitions in them. So in that case, if it meets the requirements for especially commissioned work, but it would have to be an express written agreement that's signed by all the parties that says it's a work made for hire as well. But in general, as you can tell, we would need many more facts to determine whether it would be a work made for hire here. Great question.
Thank you. We've had a couple of people ask different versions of a question about releasing a new version of a song or updating a blog or new versions of different things. And does that need to be re-registered if it's a new version?
I can take this one. So, especially in the context of musical works, the addition of like something like new music or lyrics, like a new bridge or a verse, may be registered if the additions themselves are original authorship. So, small changes to contrast that are, something like changing he or she in the lyrics, and in that case, that's not going to warrant the need for a new registration. The same goes for a sound recording as well. So additional sounds that may have been added to a pre-existing sound recording, they can be registered again if there is that sufficient amount of creative original sound recording authorship in the new sounds. So that answer applies, of course, to those other works that George, you mentioned regarding blogs and if there's visual artwork questions as well. But hopefully that's a kind of a good takeaway in terms of what has to be there for a new registration.
Thank you. We have a question about what needs to be submitted, especially when registering music and lyrics from a published album. Does somebody need to actually submit a physical copy of their work? Laura, would you like to take that?
Sure. So we talked about deposit requirements a little bit during the presentation today. So generally speaking, you'll want to confirm deposit requirements depending on the registration application that you're submitting and what type of work you're registering. So because they could be different, as Jessica mentioned, based on whether or not it was published, where it was published, and what format it was published in. But generally speaking, I can just mention a couple of the requirements for the GRAM in particular, since that's the group option that we went in depth on today. So for the GRAM, the musical works option, it's strongly encouraged that you upload a digital copy, whether or not the album was distributed digitally or physically. And if you choose the sound recording option, that's going to depend on how the album was originally published. So if it was distributed only digitally, you can upload audio files and you can upload digital copies of those artworks, liner notes, and photographs if you're including those in the registration application. If it was published in a physical format, though, you will need to deposit the physical format. And if the album was first published in the United States and in the physical format, you do need to send 2 copies of the best edition. So hopefully that helps get you started on some of the basics for deposit requirements.
Thank you, Laura. And lastly, there's somebody thanking us for our service as U.S. government employees. And I would like to turn that around and thank all of you in the audience for being so engaged and interested in this presentation. We really, really appreciate your participation in this, in the chat and Q&As. That's really wonderful. And with that, I pass it back to Jessica.
Thank you so much, George. So thank you all, as George said, for your questions today. If we weren't able to answer yours, definitely feel free to contact our public information office and they'll be happy to assist you. Additionally, the office has a ton of resources available to help you learn more about copyright. We mentioned a few today, including learning engine videos on YouTube, circulars, and then of course the copyright public records system. So you may also want to refer to our events page where you can find recordings of previous events that might be helpful, including the February webinar that was part 1 of this series that you're attending today. It of course covered copyright essentials for visual artists and photographers. Lastly, there is an important resource we want to point out to you today before you leave, which is our Engage Your Creativity web pages. So they are actually pictured on the laptop screen here, and they are dedicated web pages for specific professions. As an example, the one shown here, What Musicians Should Know About Copyright, provides some of the specific resources that we talked to today for songwriters, composers, and performers. And so we'll provide that link in the chat. Lastly, for updates from the office, you can also subscribe to our Newsnet, our digital newsletter, our blog, other events and legislative developments at the subscription link in the chat. And then you can also stay up to date on recent developments and follow along, as we release new resources on X and LinkedIn as well. Just a final note, finally, before you go, we wanted to wish you all a very happy World IP Day. So World IP Day falls on April 26th every year, and it was designated by the World Intellectual Property Organization, or WIPO, to increase general awareness and understanding of IP. So that includes copyrights, patents, trademarks, and industrial designs. And this year's theme is very on point for today's webinar, IP and music, feel the beat of IP. So we couldn't let today conclude without mentioning that. Music, of course, is a universal form of creative expression. It's highlighted across industries from film to entertainment, technology, and fashion. And this year's theme essentially invites you to explore how IP rights empower creators and entrepreneurs to bring fresh ideas to the music industry. So we hope you'll join the office in celebrating World IP Day around April 26th on social media and by reading our Newsnet and other announcements, as well as resources that we share during that time frame. And with that, we want to thank you all again for attending today's Copyright Office webinar. A survey will be sent out to attendees, and we welcome and appreciate your feedback on today's event. Hope you all have a great day. Thank you.